Yes, item 4009 is an ordinance, also on its first reading, an ordinance amending section 294.02 of the codified ordinances of Jackson County to remove the phrase state law and to re-index section on its first reading and setting a second reading and public hearing also for April 23rd, 2003 at 2 p.m. in this courthouse auditorium.
So, Mr. Chair, this is a very minor change to our hearings officer ordinance, and the author is here for a brief explanation.
Doug, you want to go ahead and do that? I know it does sound rather strange, re-index section.
Yeah, so basically all that is just a typo that I noticed when I was going through the more substantive change, which is the changing of the wording to remove the just a single phrase of state laws. As much as I tried to make it exactly perfect when I brought it to you the first time, and I did have a phone call from a local attorney that was representing the ACLU, and was concerned about the hearings officer ordinance. And so after we discussed it for some time, he called his people and he said, came back and said, you know what, you're right, everything's just fine except there's one little thing. He says, the point is that, and it's true, our intent is to have a hearings officer who have jurisdiction over county matters and of county concerns, and you have in here something here that refers to state laws. And I looked and I said, oop, you're right. In my eagerness to include, I must have just missed this one, and I saw that it did say state laws. I agreed with them, and it's not a matter. It's not something that the hearings officer would have jurisdiction over. It has no intent to do that. So removing that just eliminates that possibility. If there are some things in state law, it doesn't mean that the county couldn't adopt them, like we do, for instance, the building codes and stuff. But in this case, if it's a state law and our county doesn't have an ordinance that deals with that, then that's not something we would be handling in a
Even though our ordinances would automatically have in the adoption any state requirements eliminating the state law.
That's correct. Right. It was really more almost in the preamble as opposed to anything else. It's the only, I looked all the way through everywhere else, and there's no other place do I ever put in there anything that would somehow involve state law issue that we would be dealing with.
Yes, I would entertain.
Mr. Chair, I move that we approve the first reading ordinance number 2003-13 in the matter of amending section 294.02 of the codified ordinance of Jackson County to remove the phrase, quote, state law, end of quote, and re-index section. Second reading and public hearing be scheduled for Wednesday, April 23rd, 2003 at 9:30 a.m. Courthouse Auditorium.
I'll second it. It's been moved and seconded. Roll call?
Mrs. Capellas?
Yes.
Dr. Gilmour?
Yes.
Mr. Walker?
Yes. Well, that concludes our regularly scheduled meeting. And we will, first I'll ask the board if you have any comments you'd like to make before we open it up to Sue. You have to go. Go ahead. Yeah. Thank you. Anyone in the audience wishing to speak? We have 5 minutes allowed. Come on up.
Morning, Commissioners. Curt Chancler, Central Point. I salute you on your video. I couldn't see anything that I could argue with or anybody else could. I think a healthy economy and a healthy environment and our woods run hand in hand. I was also glad to see the last explanation on Codified Ordinance 294.02, the phrase state law. That's been a concern to us in that ordinance also. Also last week when I was here, Council Mike Jewett brought up that I had some reservations about this law that you're trying to put in ordinance. And he said that quasi-governmental agencies and quasi, so I got looking up quasi, and it's really interesting. We find out that law professors protesters all over think that quasi-judicial body is either judicial or it's not. That it can't be quasi because our rights aren't quasi. And we found out it was really interesting. The word quasi, looked up, means actually, seemingly, but not really, in some sense. I find that when we're dealing with rights that are not quasi, our rights aren't quasi. Why do we have quasi remedies dealing with rights that aren't quasi? And can we take, like, to these rights, quasi rights, quasi remedies, do we pay for those remedies with quasi money? Or can we have quasi compliance with the findings of this organization that's quasi? And so quasi, we're looking into that. It's one of the most fascinating words, and I'm really curious with these quasi-judicial refers to administrative tribunals, but it doesn't say anything about our rights being quasi. Only the remedies to problems that come up being quasi. We refer to quasi-judicial, quasi-rights, quasi-power, but our rights are quasi. And I'm really curious how we're coming up with quasi-remedies to rights that are anchored in state constitution, federal constitution, state law, federal law, and rights that are given to us by God Almighty. By the way, it was nice to hear the prayer again. Thank you. And so this quasi thing really bothers me a lot. And I would like to know more about how the word quasi, quasi-government, quasi-tribunal, how all of these play a role, a serious role, in rights that are not quasi. These young men and women that are in Iraq right now are not fighting for quasi-rights, are quasi-remedies to those rights. And I'd like to ask again that the board reconsider before implementing this till it can be looked at a little stronger. I'll ask again.
I might respond to that when being asked what quasi-judicial decision-making includes, is that I always remind myself to carry around this little description of what that really means here when it follows, or in regards to state land use regulations. And it is listed as following elements: notice, clear and objective decisional criteria, an opportunity to be heard, a fair and impartial decision maker. And that's, I think, part of what we're trying to accomplish here. The right to present evidence into record, a written decision with findings of facts and conclusions, which is what we try to come up with, and the right to appeal, a brief explanation of each element then follows. And I carry this because it kind of reminds me of sometimes what we allow in the process of providing government, and something that isn't just necessarily black and white, and especially when you have a state that has the land use regulation that Oregon does. And I don't know how you would ever get to a decision without having the quasi-judicial process, because a lot of it is not clear when it comes down to the county level. We question many times when we're making a decision, what is the intentions of the LCD when they force these requirements? We make a decision, and many times it gets appealed, and they'll tell us, well, how did you believe, or what did you believe the requirements were under that? It's vague, and we have to make our decisions based on what we sometimes think is pretty gray, but it could be decided really one way or the other. That you have people sitting up here trying to decide what they meant when they made those requirements, and most of them are administrative rules.
When I went into the City Council Center Point, this came up too, and I was really puzzled by the term quasi myself. Because there, what would happen is you'd have a person would come before the planning commission and may be denied whatever they're trying to get, whether it's a partition or whatever. If it was denied the planning commission level, it would go up to the city council. And the city council would have then the ability to either deny the applicant's request or to approve it and override the planning commission. And that was considered quasi-judicial. And that's the term that was kind of thrown out at that time because it meant that we're acting like a judge even though we weren't a judge. And that's sort of what it meant at that point. I think that's what it means, that you're acting like a judge even though you're not a judge per se, as far as that type of decision making. And I think that's what it means. It's pretty odd phraseology, but that's something that's been kind of stuck there. We're stuck with it. The cities are stuck with it.
I think that the Constitution and the Supreme Court refers to it as vague and ambiguous, and it's not supposed to be in any legislation or any law.
But most of what we do here is vague and ambiguous.
Well, counsel there, Doug, he doesn't subscribe to private ownership of land anyway.
Yeah.
And in our conversations we've had, or the Constitution, or the rights to defend yourself in court, you have no right to a jury trial, as I remember in the Redler case. You have no right to a jury trial. That's guaranteed to us in the Constitution, but not here.
You've got about 7 minutes on there already.
Well, let me
You
get
ran out of
that.
time.
Okay. Give somebody else a chance. Thank you.
Okay. Anyone else wishing to speak? Now, we're only going to get 5 minutes, I think.
One question. Jean Wallman, Eagle Point. My question is if you do not want to go before this, can you go directly to circuit court? Can you be put right in? Now, Jack at one time gave the indication you could, but when I spoke with Mr. McGeary, you could not. I just would like that clarified.
Well, let me clarify, I think, what I said first, and then is, if you did not like the result of this, of a decision made, then you certainly have the right to take it to whatever level court you want it to. Is that correct?
That's correct.
And that's the basis of it. You would have to hear it on the lower end because they would not accept it in the higher level courts because you didn't go through the process to get there.
That's what I needed to know, because I understood that we could, at the very beginning, that if we decreed that we would rather go to circuit court than the quasi-court, we would have that right. We do
Do you
not.
really?
No,
I don't think so.
you would not. I mean, that would be.
So, that, once again, the citizen is cut out of the process in that they don't have a choice.
Well, you don't have a choice if you go to circuit court either. If someone charges you with a violation, you might want to go to justice court, or you might want to go to some judge or to city court. That wouldn't happen.
But those are justice courts, and I guess that was my question. This is a quasi-court administrative. It is not an American judicial court in any way.
Well, in a way it is, but it's not.
It's
You're right,
quasi. It's quasi. Okay, thank you.
Yeah, it's
We did not invent that word.
Yeah.
No, I knew you did.
Okay. Anyone else wishing to speak? Seeing no one rushing up here, I appreciate you all being here today. Thank you. We'll see you next Wednesday, we hope.
Next Wednesday.
Oh,
That's
next
right.
Wednesday, we canceled that one.